Good afternoon, everyone. There might be a bit of change. I must confess, I'm as a legal counsel at Accenture, the large, technology and professional services consultancy company, and my role is to support their digital business, so all their new technology. So we're going to be looking today. My talk is to give a sort of high-level view of some of these technologies and look at what companies are doing in this area and the developments, and then just to sort of pose at a high level some of the challenges and opportunities for intellectual property and intellectual property lawyers. And then, as we planned it, Kevin afterwards will be going and talking a little bit more about detail about some of the practical implications of IP in these new technologies. So first thing I want to do before we look at any particular technologies is to just spot some of the big themes that you'll see coming up that link all these sort of technologies. The first is really about networks on connectivity. You think of the internet, you think of Internet of Things, devices, and one of the big trends is really the connectivity that people have, that people connected to people, people connected to devices, and indeed devices and machines to machine. These days, no one's ever really far from their smartphone or wearable app, wearable device, and there's a constant flow of information, and that's really onto the second thing of data. What this is all really about is the flow of data between companies, between people, and that's really valuable because it allows companies to focus services and products, personalize them, and to have the right service at the right time. And this is really valuable for businesses' efficiency and for their marketing, and to really tailor services with that knowledge. And then the last one I just wanted to point here is trust. And you'll see this is really important. It's less of the theme of technology, but it's the real barrier to implementation of technology, because the ability to create devices, the ability to create the software and the solutions, that's developing, but it's only with the trust of people that will be endorsed and people will take on the services that they can do. You have to be able to trust the technology and the services to really want to adopt them. So what sort of technology are we talking about? Well, I put some of the ones up here. I'm going to talk a little bit more about artificial intelligence and blockchain. But you can see there's a whole range of technologies. And I'm sure you can think of examples in your own life on things on the news, such as driverless cars, 3D printing, of how these are changing the way that businesses operate, the way that people can use technology to communicate in the workplace and tell workers where they need to be at any given time, or do maintenance, just-in-time maintenance on infrastructure, or monitor how productivity is going. And in our own lives, you think of internet shopping, all those recommendation engines to find more personalized services and products. So there's a wide variety of technology out there. And before we talk a little bit about the intellectual property and what this might mean for IP lawyers, I just wanted to talk about two in particular that are really important. The first is artificial intelligence. And this is really, in its most basic, the step up from computing. If you think about going back to the Second World War and the Enigma project, why people created computing. Computers have always been smart at processing. We love them because they have much bigger memories than we do, and they can process data much faster, find information. I think most of us today couldn't live without computer technology. But the next evolution we get into is, what if computers get really smart? What if not only can they just follow the instructions that we give them, but they can actually, in their own sense, sort of think and learn. I mean, you think about us as lawyers, how we learn. you do something, it works, it doesn't work, you know what to do next time, you learn from the experience, you take in information from all the things around you, and you create patterns, you make associations, and you learn that's associated, that's a bit like that, that's enough, yeah, that's one of those. And we're getting to the next stage where we're getting technology that can do this. I quite like this, a cute little slide about data coming in. All this is about information. So just if you like categorizing a bird, these artificial intelligence, machine learning, they look at information, they see lots and lots of it, and they have the ability to make the connections. And then work out, what is a bird? What is it? Yes, no, it meets this criteria. Yes. And then what about penguin? And look, and then we'd instinctively know because we're taught a penguin is a bird, but it's learning how do we know, what is it, categorize it, and having computers and algorithms that are able to do this, and that's what it is. It's clever technology, and I'm sure Kevin's able to tell in much more detail with all their Watson project about how this actually all works, but it's very clever technology that allows learning, and this is going to revolutionize think analytics and learning and services. Not only do you get very, very smart analytics at the back end, but you're getting technology. You think of things like Alexa now are able to communicate with people, who read emotions, to read situations, think sort of like a human does in the mixture, and be that flexibility. Computers are good at the hard processing, but it's that soft, almost intuitive thinking that we do, almost the unconscious stuff that computers traditionally have not really been able to do, and artificial intelligence is starting to bridge that gap. And there are lots and lots of uses in customer services. You think these days when you go on a website, more often than not, you're talking to a computer, one way or another, a bot to answer your questions. At the moment, most of what they can do is quite limited, but one day, they're probably able to answer most of the questions in a way when you ring up a call center that they would do. And the other bit of technology, moving on, that I just wanted to talk about was blockchain. And it's something, again, that I do a lot of work with. And blockchain is really the next evolution in record keeping. So, this is, there's a lot of myth about blockchain and the complexity of how it works. But in its essence, what blockchain is always really about is record keeping and transactions. So if you think that, people have always kept records, if they bought or sold something, it's recorded somewhere so someone knows what's happened. And these days we do it by computer, so nobody keeps paper records anymore. I'm sure it's a long time since even lawyers had lots and lots of paper files. It's all on computer, but blockchain is the future of maybe networked. And what the advantage is with blockchain is the distributed ledger. So instead of having one place where all that information is kept, you have every person in the network has a copy of that record and can see that record exactly the same as everyone else at the same time. So you get a greater sense of visibility, and with that trust, it's single source of truth. You can see exactly what is going on all the way through the network, and authenticity. So the way that blockchain adds, when there's a transaction or something to be recorded, there's a process of verification that goes on. There are various ways that can be done, but once it's added to the blockchain, it is actually there, and it's there, the record. You can't erase the record, you can't change the record without everyone seeing it. So there can be no sort of fraud or fiddling the record, as is sometimes a risk. So you get that authenticity and no single source of failure. So in the way that, if databases get corrupted or someone goes out, that's the whole thing going down. So you've got a robustness, a visibility and a trust with blockchain. And that makes a big difference to what can be done. You've got the traditional kind of transaction where you've got many layers of people to go through to talk to. With blockchain, everybody can deal directly with everyone else. Everyone can immediately see the records, see what's happened, trust it. So it means that particularly for things like trade finance, identity documents, property records, intellectual property records, you can see more quickly everything, the record, and check the validity and the history of it in a reliable, visible way. So that's very briefly about just some of the technologies and how that is changing the world. But what does it mean to be an IP lawyer in this area? Well, the obvious one, and first of all, very good news for all of you that are IP lawyers, particularly patent lawyers, is there is a lot of IP to protect. So all these technologies at their heart are software, algorithms, hardware, obviously data, and huge number of copyright, design rights, database rights, and particularly blockchain patents. We saw similar slides earlier today showing the increase in the number of patents in the countries. And so blockchain, there's been a huge explosion in the last few years of patents. So there's plenty of work out there, both in terms of patent filing and, of course, then protecting and dealing with potential infringements and clashes. And it's a global market, again, showing, similar to the slide earlier, China leading the way. But, this is something that's going on all around the world. This new technology, the innovation and the possibility is driving people to take protecting their intellectual property really seriously. And some of the other issues is, first one's really about my world of putting together sources, is really about ecosystems. So, with these particular things like blockchain, yes, I talked about it being proprietary and wanting to protect, but also it's very much that it only works, really, if you think about a network, it only works if many people are involved. You need to go out there and work with other people. So, do you open source it? Do you have common standards? Many of the underlying technologies like Hyperledger, Ethereum for blockchain are open source. But equally, so quite a few now are coming on that are actually proprietary. And many people, like Accenture does, builds and adds components and other products. So what you're looking at with many of these sort of blockchain and smart contract solutions that sit on them are complicated ecosystems of a mixture of open source, which is obviously freely available but has its own licensing challenges and potential restrictions, particularly making sure that it's not one of the ones that goes viral and makes you having to disclose the source code of the whole solution, and the proprietary and the rights. So getting that right and getting the right protection and product for those transactional IP lawyers like myself is a real challenge. Data is interesting. I talked about the value of data and how important that is for business. We're really getting to be a data-driven economy. What it is now is everything making informed decisions. If you know more about yourself, your business, your customers, you can drive efficiency, you can find those opportunities, and you can reach whoever it is, if it's another business or the consumer, you can reach them much more efficiently to find out what they want and how you provide whatever it is you're doing to that person. But data is, I think, in some ways notoriously hard to protect in an IP world. I mean, the main ways, sometimes you have copyright or database rights, depending on what it is, but most of the time it's through trade secrets and confidentiality, which is still the core of where we are protecting data. But it is valuable, and it's not always about being secret. Knowing stuff about customers, blockchain, you have to share information, but it's still valuable. How do you share it? How do you protect it? And I think it's very noticeable and very significant that, for example, the European Commission is looking at data rights. So not just personal data. So obviously, I'm sure many of you know about GDPR, the Global Data Protection Regulation. It's the new law that's just come in. So there are, in Europe and indeed in many parts of the world, there's lots of data privacy laws which are talking about controlling and protecting personal data. But data as an asset, what about business data? What about other types of data? And the European Commission is looking at whether those sorts of whether other sorts of data should be protected as an asset and sort of be more like a traditional IP class, or is there a way to protect data? So I think you're going to find those sort of conversations coming more and more about how you control data, how you protect it. And that's obviously another field where I think IP lawyers will have a lot of interest. And then finally, I said ownership of IP infringement issues. I'm sure many of you remember, I didn't put it up for copyright reasons just in case. I may add, for those who noticed, that's anyone's Game of Thrones up there. Not there. We own Macavision that do the 3D special effects on Game of Thrones. So I thought it was a good example of augmented reality and special effects to put up there. I believe I'm allowed to put that one up there. But on the famous monkey picture, you remember I think it was a baboon or something that took its own selfie, and they went to court about whether a monkey is an author of its own photo. But we're not quite there, but you think about artificial intelligence. At the moment, I think it's pretty clear with almost everything that technology, it's the developers of the technology that are, that create it and create what they do, and are also responsible again for what comes out and what it does, both in things of liability but also infringement. But when you actually get into artificial intelligence that is getting to the point where it's pretty autonomous and it's not directly under the control of any human, or not even predicting what it's going to do, because that's the point about learning like we do. I mean, humans are unpredictable. What when artificial intelligence, what if they actually create something in the future? Can you really say it belongs to the person that wrote the original code? Or are we going to have to start looking at new categories of author, of entity? And again, infringement, if it's your computer that's infringing, but you were like, I had really nothing to do with it. I never told it to do this. I had no control. Is that going to sit comfortably that somebody is liable for infringement when they say, nothing to do with me, I was just using it, I didn't tell it to do that. And then finally, before I hand over to Kevin, extinction, in terms of our own practice, I think there's no doubt, I alluded to this with blockchain, that many of these technologies are really useful for lawyers, just in terms of record management, record keeping, helping provide services. We're looking at ethics, but internally at the moment just having little chatbots to answer simple questions. So there's no doubt that even for lawyers themselves, this technology is really helpful for things like due diligence, things like discovery of speeding up. The question, extinction, will you one day get a computer that's clever enough to do our jobs, and we'll all be out of a job? I think probably not quite yet. I think probably most of us are going to be safe enough and be able to enjoy the benefits of this without the risks at this stage. But it is an interesting question, at what point the technology is smart enough to start giving advice. If you think about what we do, analysing data, making judgments, giving advice, in some ways that's actually what computers are quite good at, with a little bit of thing. What they're not so good at, of course, is the people stuff. And I think going back to that trust part and the people empathy part, I think it will be a long time before anyone is going to want to completely rely on computers and technology to run your patent portfolio or to provide complicated IP advice. But it is interesting that the technology is coming, and I think there are obviously really great opportunities for IP lawyers in this area, but there's also some challenges, and there's going to need to be some adaptability. So with that, I will hand over to Kevin, who I think is going to talk about some of today's challenges. Unless someone's got it, maybe we'll take questions at the end for both of us.
Yeah. Makes sense. Thank you. Okay, I'm Kevin Fournier from IBM's IP legal function. I'm going to talk about three technologies, mostly blockchain, a little bit of AI, and a little bit less of IoT, just because that's my experience. I've worked a lot with blockchain. And so basically I've titled this New Technologies, Old Legal Structures, because the technology changes, but the law stays the same, and we have to fit and work with these new technologies with the old structures of the law the way they are. And a key example of this is trying to get some of these things patented, as some of us have first-hand experience with. Okay, so blockchain. We've already heard what it is, but just very, very quickly, just in case, just to double up on this part, I think is quite important. You've got lots of parties, and they want to interact with the same universal source of truth. So everybody sees the same state of a transaction, as opposed to having to send like letters of credit or bills of lading, or things. You have to wait for the ship to turn up with a piece of paper that says that something's being mailed, and what's being mailed, and who's paid for what. There's no intermediaries needed anymore in blockchain. It's all done with a distributed ledger, so everybody sees the same database. And basically, you don't have to trust people anymore. That's what it comes down to. Okay, so an example, trade finance. I've worked on a deal in the trade finance area for blockchain where we've had about 6 different banks as customers. And what you'll find in blockchain is that because it's a distributed technology and lots of people have to play to make it work, you don't have just one customer, you have 6 customers all at once. And you have to negotiate with 6. I have to negotiate with 6 customers all at once, and it's not easy. Negotiating with one customer can be difficult, but negotiating with 6, it's very challenging. So, an example of a deal that I worked on recently with 6 banks is in the trade finance area. So, you have a French wine seller, and he's got crates of wine. And he doesn't want to ship those crates of wine until he knows that the restaurant in New York has actually paid for the shipment, because he might not get paid for it, and then you don't want to put it in the mail. Likewise, the restaurant in New York doesn't want to pay until he knows that the crates are on their way. So it's a bit of a chicken and egg situation. So blockchain will help by you can see the restaurant in New York and the wine cellar and everybody in between, the shipper and the people who put it onto the crates into the ships. Everybody can see, the customs officials, where it is in the process, who's done what. There's no need to trust. It used to be done with letters of credit. You'd get these pieces of paper to say that something's been put on the ship at a certain time. All of that is no longer needed anymore with blockchain. So it's a huge revolutionary change in the technology. So basically, how is the best way to explain the architecture of blockchain, so that you'll know how, when you see like patent applications or examples of the technology put into practice, is to think of it as a layered approach. At the very lowest layer is the high-tech layer. Basically, this is where all the technology stuff actually happens, and this. IBM's version of this is called the Hyperledger Fabric. We wrote a lot of this and donated it to the open source community. And it does the very basics of the technology of allowing the distributed data to move around between the parties. The middle layer is technical functional accelerators. So something like identity management would be one block that sits on top. Digital rights management functions that will be repeated in lots of industries, little blocks of software that you can reuse. And then at the very top is the chain code layer. And now this is business logic. They call it smart contracts, which is a particular bank would have particular rules that, if somebody doesn't pay, make a payment by a certain amount of time, then certain consequences happen. It's business consequences and rules are implemented in software at that higher layer. Now, that higher layer is probably not going to be patentable. It probably would never pass the Alice test. But the lower levels, the high-tech layers, would probably would. Okay, so A and B, the first two, are probably analogous to an operating system in the old days. It's what makes everything work, and applications layer C sit on top of it. Okay. Sorry. Okay, so yeah. IBM was a major contributor to the source code for the Hyperledger, that bottom layer, and because it's open source, there's certain legal implications for it. The particular open source license is called Apache version 2. So what happens here with Apache version 2 is that any patents that you have, if you wrote that software, any patents that you have that cover the software that you wrote, you have to basically license people for free when they download that software. You can't go after them for patent infringement. It's royalty free. Now it doesn't just cover that. It also covers combinations of your contribution with what's already there. So if you write some software and the patent claim happens to cover has some elements that cover what you contributed and then other elements that cover what's already there, then that too you can't go after people for infringement. So that's part of the Apache license. Okay. So IBM's role in blockchain is developing the Hyperledger fabric and then going out to customers such as these banks that I mentioned and writing that code that sits on the top layer in order to make blockchain do things for people, because blockchain won't do anything at the Hyperledger layer. It's got really fancy technologies, but it's not doing anything. It's just waiting there to be finished and to actually do something with. So the real money is made by going in and bespoke solutions for customers, which means that the software is being developed in front of people. It's not. It's no longer a case of being in a lab behind closed doors, developing a product, and then releasing it to the public, and then everybody gets, sees this new product. What's released is like a half product. It's the open source Hyperledger is like part. It's not the whole thing. It won't actually work. You customize and bespoke solutions sitting on top of the Hyperledger that actually make something work for people. So that means that you get into all the issues that customers would normally raise, like, well, you're making it for me, then I have to own everything, right? And you can't go anywhere else and use it or use the same people to develop this with anybody else because I paid for it. But however, that's the old legal structure, where customers own everything. But this new technology is different in that you have to build all the time. So if you box yourself in and you don't keep any rights to build things for other people, then you're going to find that your blockchain business is not going to survive. So that's a constant tension that I have to deal with. So one thing, when customers say they want to own the IP, they often don't know. They often are not clear as to what they want to own. They just say, I want to own the IP. And I often say, well, what do you mean by IP? There's no definition. I mean, we haven't defined it yet. It could be a lot of things. I mean, I think it probably means patents. It probably means copyrights. But does it mean know-how and trade secrets? Because if it does, we could be in trouble if we assign that to you, because this is very contaminating. If we assign every single piece of know-how that we come up with while we're developing this solution for you, we're going to take these developers. They're going to come up with lots of new ways of doing things. Some of them are going to be very small, like a new way of storing data into a log file, for example. If we come up with that and then have a broad IP assignment clause, we assign you all the IP that we create in the performance of this contract, then that little technique for storing data into a log file is going to be assigned, and no patents ever filed on it. When these developers move on to a new project a year later, and they find the job that they have to do is to put data into a log file, there's a very good chance that they're going to do it in the same way that they've assigned to customer A, and they're going to customer B, and they have to put data in a log file. They're probably going to do that again, and then customer A comes after us for misappropriation of trade secret claim, and yeah, we're stuck. So what I do is to avoid this contamination risk by trying not to assign the know-how. So we'll assign to you the patents if they push us. We try to keep the patents if we can. But if they want us to assign the patents, then at least we know if we assign a patent, it's granted, and you can find it on Google, and they're around, and you can read them, and you can stay away from them. But know-how is it's not, you can't really do that. That's one thing you can do. But then if you assign the patent but you don't assign the know-how, you get into this issue of how do you how does the patent owner, your customer, protect themselves from you that owns the know-how going out and disclosing that know-how to customer B, their competitor, before customer A has a chance to file the patent. As we've heard this morning, there's issues of prior art, of disclosing things, and if we go out because we own this know-how and start disclosing it left, right, center, customer A is not going to have a chance to file the patent. So some mechanism in the contract you have to arrive at where maybe you give you get notification from customer A as to the fact that they want to file a patent, and then they have to tell you in some specificity what is the problem solved, what are the advantages, what are the technical features that lead to that advantage, and then we can stay away and we can not use that invention for maybe a few months or a set period of months to give them time to file their patent, and then as soon as they file their patent, we can start disclosing it and using it because we own the know-how. If we have a license, to that patent. If we don't have a license, then of course we can't. We know that we have to stay away from it. So there's mechanisms that you have to, put in place for that. Like copyright now. If you assign the copyright, then usually it's a very bespoke solution for a customer, and it's full of confidential information of the customer. So if you assign the copyright and you never can use that software again, that might not be a bad thing because you probably can't use it again because it's probably full of the customer's business confidential information. That chain code layer is how their business works. What business rules they've given you that they won't implement it. So you probably can't use it again. But as we all know, there's two types of copyright infringement. There's one where you go up to the photocopy machine and press copy and your copy comes out, right? That's copyright infringement, obviously. But there's another type that is not so clear, and that's the unintentional copyright infringement. And this is where somebody sits down, like a musician today would, well-known musician today would sit down at a piano and write a song, and he thinks it's a lovely melody, right? But little does he know is that it sounds like a song from the 1960s. It's the same melody exactly. But he thinks he's writing it from scratch. We've seen lots of lawsuits in the press about this kind of thing. Sometimes it goes one way, sometimes it goes another. For George Harrison, it did not go well with with My Sweet Lord. So you use the same developers, and they go to customer B, and they write some software for customer B, and that software ends up looking a lot like the software that you've assigned to customer A. So you've assigned the copyright, so you've got no rights to do that. So little do you know, you face a claim of copyright infringement when you go to customer B. So to protect against that, what I tried to do is to put a clause in the contract that will say that in the event of that happening, we have the right to create and distribute externally materials that are substantially similar to the materials that we've assigned to you, as long as we don't use them, access, or refer to them in any way. So you have to do it totally from scratch, totally clean room. The people you cannot have that, but they cannot have a copy of it in front of them when they're going to their next customer. So that's a possible way to protect the ability to do that. Because blockchain is all about reusing the people that you've got. That's the key assets. The key IP really is in the minds of your employees that you've hired, because it's such a evolving technology that people, the value is in people's heads, and holding on to the key people and being able to reuse them. If you find yourself in a position where you can't reuse your people, you've lost the battle, really. Okay, so when patents are not assigned to the customer, because there's such a big collaboration going on here, you get into issues of joint ownership. So joint ownership, I've never, in the last year or so, I've not seen so many issues of joint ownership as I've seen. I've had to totally, beef up my own joint ownership skills, because it hasn't come up before too much. But basically, because you get 6 customers, and how do they divvy up the ownership? They're not going to give it to you. They're not going to give you the ownership. So they're going to own it themselves, and not one is going to own it. They own it jointly. Sometimes they let us be one of the joint owners in one. But we don't get any rights. So it's just the same as giving it up. Really, you can't do anything with it. You might as well not be a joint owner. What happens? You need to decide about ownership, and you need to decide about accounting and consent, because who can license this? Can you license it separately from the other owners, or do you have to get their permission every time you license somebody? And do you have to pay them every time you license? So you have to deal with that in the contract. And then, if you do file patents, who's going to pay for these patents, and who decides where to file and how to prosecute them? All that has to be decided. And what happens if somebody wants to file in a far-flung country and the others don't? What do you do about that? So then the enforcing side of it. If somebody wants to sue an infringer, one of the joint owners, then the other joint owner can just come in and give them a license, and the lawsuit's over with. So how do you deal with that? And the thing that is particularly interesting, and you have to guard against, is what if somebody wants to sue one of your friends, like a business partner of yours, and you don't want to have to be a plaintiff suing your friend. So you got to put in some wording sometimes. I mean, one thing that I tend to do is to say, well, if one of the joint owners wants to sue one of my friends, then I can give up my ownership right. I'll assign to you my joint ownership right. Then you can sue my friend, and then I get a full license. But I don't want to be a plaintiff suing one of my friends. So that's one way around it. Okay. So if you do file patents and you do own the patents, because these inventions are created in the context of a customer every time, and you're not creating it in a lab like in the old days, you can't just file a patent and just think that I can put anything that I need to put legally into that patent application, because that's how I've always done it. The customer is telling you a lot of stuff, and the specification has to describe like a working example of the invention, and if that working example includes stuff that the customer has given you, it could be confidential. You might not be able to put it in the patent application. So you might have to be clever and come up with some kind of generic embodiments that has no confidential information, and it might not be possible to do that on a case-by-case basis. It's just something to think about. So here's a quick a list of the things in blockchain that are probably patentable. The areas that you could probably, because in the U.S. as well as in Europe, there's, as you can't patent things that are not technical. If they're business ideas, you can't patent them, but if they're technical, you can. So these are the kind of areas that are probably okay to file patents in. Peer-to-peer replication. Each party to the transaction has a copy, and you can see everything, and it's mirrored all over the place. That kind of mirrored replication. How that happens, there's probably lots of patents that could be filed there. each change in the transaction is verified by a consensus. Because if somebody makes a change to the blockchain, you need to be able to know that change was okay. You know, it can't just be one person making a change. Everybody has to agree that that's the right change. You know, or not everybody, because it's a majority, a consensus. Because you might have one party that doesn't want to agree, or thinks it's not right, or can't be found on a certain day. So it's the majority. Consensus mechanisms are probably patentable. Authentication, there's a lot of patents on encryption, as we probably know. Coding, that's patentable. And hashing algorithms and that kind of thing. So those are the areas in blockchain that you probably will see patents. And if you had a good look at the hundreds of patents that are out there, you'd probably see a lot falling in these areas. The chain code, like I said, is too business focused. It's probably not patentable. There's something called smart contracts, which is if you don't pay your credit card bill by a certain time, then you're going to get an interest charge, and then it all would happen automatically on the blockchain. That's probably not patentable. Okay, so these are the kind of non-technical areas. So one decision to make is should you patent or should you keep it as a trade secret? If it's visible and it's out there and everybody can see it, then you might want to patent it because you're not going to be able to keep it as a trade secret. But if it's in the inner workings of a cloud and nobody's ever going to see it, then if you keep it secret, you might be better off. Because once you patent it, then in 20 years, who knows if we'll be talking about blockchain in 20 years? But okay. So divided infringement. Okay. So you got a method claim, and there's a bunch of steps, and some of the steps are done by one person, some of the steps are done by another, and some of the steps are done by another. And with blockchain, that's how it happens. Everybody's doing something. It's a collaboration. So what good is a claim that you have three people infringing? I mean, it's kind of hard to make a case that who do you sue, and when you do, you have to make all these arguments that this other party is liable as well, and good luck. You got to be very careful, and in my experience, software claims usually is the method that's the critical one, and the other ones kind of follow. That's how I draft anyway. It seems to be the way. You get your software algorithm or is a method of steps, and it's hard to get them in blockchain to all be done by one party, but it's a challenge. Secrecy orders. There's a lot of encryption, as I said. If you have we have inventors in lots of different countries, right? So it's often interesting to think how they could invent these things when they're all in different countries. But I guess the telephone that they who knows. Which country do you file first in, and what permissions do you need to get? You need to think about that because they're not being developed in your local lab. You just file in your local patent office as your priority document. You need to think about, whether you can even file it, in another country, or sometimes you can't file it at all. It's the problem, with the problem sometimes if you get two inventors from two different countries and it's a highly secret technology, you can't file in one patent office of one inventor. Because it'll prejudice the other inventor, and then the same for the other patent office. So you could end up in a position where you can't file a patent at all because of that. So it's just something to think about with blockchain. Here's a quick example of a patent that we filed. That's been published recently. Donna Dillenberger is one of our key blockchain researchers. So you get a personal blockchain ledger, and usually the data is just put on there. Crate of wine was put on the ship, on this date or whatever. In this invention, you encrypt that data before you put it on the blockchain, and the holders of the keys can share it with only the parties that they want to see the data. So you can give a certain private key to your doctor, and only your medical record can only be seen by that one doctor. So it kind of limits, who can see things. These are the top patentees in blockchain. We originally were going to focus this talk on landscaping, but this is just a kind of a list of the. You can see that banks are there, financial institutions are there, as well as technology companies. Some in the U.S., many in Asia. very sad to see that there's none in Europe, but hopefully that will change. Okay, now I'd like to shift gears. How are we doing on time? Okay?
We're done.
Oh, we're done.
Take 3-4 minutes.
3 or 4 minutes. Okay. Very quickly on artificial intelligence, I got much less to say on that. So like in blockchain, it's done in collaboration with other parties. You have the same issues again, because there's a base level, IBM's got something called Watson, which is a base level artificial intelligence engine. And on top of that, it needs to be built on, like, for specific use cases, like maybe the Portuguese language or Finnish language or something that's not done very often. We would work in collaboration with a partner that would know the details of the taxonomies, because with artificial intelligence, it's all about content. What content does the software have access to, and is it just Wikipedia, or is it Wikipedia in Finnish? So because when you ask it a question, it needs to be able to have the content there in order to provide the answer. Contamination risks are all over the place. We talked a little earlier about working with a third party, when you're a small early entry, and you can run into patent issues, but it's also contamination. You work with another party, you're going to be learning a lot about their technology, and they're going to be telling you things in secret. If you then go out and build your own product, then you could easily be subject to a claim of dependent innovation. So you've got to be careful of that. So you need to set up an internal plan to manage that risk. And what it seems to come down to is proving evidence. What do you have to prove that you came up with this yourself? Versus what could the other side prove that you took lots of stuff from them and developed using their information? That seems, all the lawsuits that I've read, that seems to be what it comes down to, the evidence that's there and with you and against you. So you need to come up with a plan to minimize the things that will hurt you in that contamination. It's very, very hard to get patents at the EPO on AI technology. If you come up with the best invention on how to find the highly, highly relevant data, you ask it a question and it comes back with an answer, and then you come up with a technique that uses the ranking of the candidate answers in a much, much better way, and it gives you the answer is much more relevant than it was before. It's not patentable. I'm fighting with the EPO on 2 cases right now, and they're basically telling me we got 5 patents in the U.S. on this on the same family, continuation, divisional, and but we can't even get the one in the EPO, because they're basically saying that they cite a case. It's a T decision, and it basically says if you search better and the search results give you a more accurate search results, is not a technical result. So so they want me to. They say if you limit it to a specific field, then you can get it. And I'm thinking, well, what do you mean? I mean, it's not limited to a field. It's a better way of getting a search result. It's definitely not limited to a field. But they think no, limit it to a field, and we'll grant it. But the EPO is very strict on you need to put something into the claim. It has to be in the spec before you can put it in the claim, right? Literal, right? So on page 1 of my spec, I've got, AI is useful in the medical field, for example. Right, so now I'm going to take medical field and transfer that into my claim, right? And they're going to grant it, right? But it's stupid, right? Because it's superficial. I can only go after people with that invention on that's using it in the medical field, but it's not that, So it just doesn't make sense. So that's very, very difficult to get that mindset changed. So Internet of Things at the very end, my last slide, is similar to blockchain and AI. There's a base layer of technology again. I think that's the theme of my talk almost, that there's always a base layer, and you're building on top of it. And the base layer for Internet of Things is handshaking. You got packet, because what it is you've got these little sensors, and they're in your refrigerator, and they're sensing the temperature in the refrigerator, and they're reporting that it's risen above 10 degrees, such as I had the other day, and all your food's going off, and And so I went and bought a one pound little thing and put it in there. But that was my sensor. But yeah. But if you could, protocols are the base layer. They're handshaking. The packets are going back and forth. Do you need to acknowledge that there's a packet that's been received, or how many do you receive before you acknowledge? All the handshaking and stuff is probably patentable. But what's probably not patentable is the fact that you've put it in your fridge. So so it's layers. The lowest layers are probably patentable. The highest layers are probably not. Okay.
I think we're a bit short of time, but if anyone's got any questions for Kevin and I.
This is not really a patent or IP question, but what are the pharma companies doing with artificial intelligence specifically? I know that some companies are investing a lot of money in their, but from your view, I'm more, I guess, to you as a consultant, what are they coming to you for in terms of help and things that they want to do?
I have to say, I know that we have a big pharma practice. I haven't, it's not from first hand. I'm sort of thinking of the sort of things that they would be doing. But I think, what really artificial intelligence is really good at is the analysis and the research, as I said. So what you, as a pharma company, what you need to know is, when you're at your drugs, how effective things are, how effective they're working from a chemical, technical perspective, but also how they're selling, where they're going, what's selling, what your competitors are doing. And those are the sorts of things where you get the right information in and you get the right things, because sometimes, pharma's very, but sometimes about how things are sold and what things look like and how you package them, etc., actually can be as important to almost to success than the actual chemical formula. So like any other business, I think that's a really important. And artificial intelligence, yes, you get the sort of the chatty chatbot end, but actually the analytics side and the thinking and the pattern analysis is actually really important. And you can understand your product in the market, you can understand what people want, you can understand what else they're buying for a similar condition or what might work. And that's where you get to, it's about, as I say, it's about targeting your product or services most effectively, so you're efficient in your business model and you're getting, targeting to the people you get the maximum returns. And I think that's the side of it where I think artificial intelligence is probably playing its biggest part.
Thank you.
Hello, I'm Develina from Wockhardt and I'm from Pharma. Just to add to what you have said, I think where AI really helps us is, in terms of patterns in litigations, parafor litigations and patent exit litigations, as also AI helps us in, studying the patterns of clinical trials and competitors in clinical trials. So those are also the areas where AI helps us. Just wanted to add to what you were saying.
No, and that makes sense. I was talking about the manufacturing, the technical side, but absolutely I've hit room for IP lawyers and mostly a lot of the pharma IP lawyers. But yes, I was going to say, obviously managing patent portfolios and knowing what else is out there and what might be patented and where the gaps are and where someone might be infringing your patent or you might be close to someone else's. All that sort of information, the analysis to help intelligently do that is yes, that's very important. It speeds up the process and makes it more reliable that you can, that you're likely to get it right, other than someone having to literally look through it. That's very valuable.
Is there any more questions? Right, well, thank you. Thank you. It was a very nice presentation.